This is Deepya MS. My registration number is 2112311 and this is the explanation of the case law Chhunna Mal Ram Nath versus Mool Chand Ram Bhagat on 1928. The suit out of which this appeal has arisen was one claiming damages for the non-delivery by the respondents of certain goods, which the latter had agreed to sell and the appellants had agreed to purchase. Plaintiffs entered into contract on November 29, 1916 for taking deliveries of the goods packed in wooden boxes from the defendants, which latter was to secure from London. The main parts of the contract read as: we had purchased 150 cases, that is 7 shipments. We have sold the same to you at a net profit of rupees 4 per piece. You shall have to take delivery of the goods on payment of their price to the bank. On April 24, 1917, that is after the date of the said contract, but before the first shipment, an order in council was issued in London prohibiting the export of cotton goods in tin and wooden cases to India, and this was followed by a similar prohibition by the Government of India. On April 28, 1917, the importers, Messrs. R.J. Wood and Co., wrote to the respondents as follows: as the British government prohibited the use of wood and tin cases, kindly note that all your goods on order will come out packed in bales instead of cases until such prohibition is withdrawn. If we do not hear from you within 3 days, we shall understand you agree to this. If not, kindly instruct us how to send the goods out. Later on, a series of letters were sent between the plaintiffs and defendants in which they went back and forth on the defendant requesting them to take delivery and the plaintiffs cancelling the goods. The suit out of which this appeal has arisen was one claiming damages for the non-delivery by the respondents of certain goods which the latter had agreed to sell and the appellants had agreed to purchase. The defendants argued that the appellants had put an end to the agreement and had expressly dispensed them from delivery at all. There was no agreement to dispense or a contract supported by consideration to do so, and that in any case it could only operate when the party dispensing had performed his part of the contract and only something remained to be performed on the other side. They further said that if they had been wrong in refusing in advance to accept the bails, this repudiation had not been accepted by the respondents at all, which means the contract remained alive and ought to have been performed. Section 39 of the Indian Contract Act runs this: when a party to an agreement enforceable by law refuse to perform or disabled himself from performing as accepted proposals in an entirety, the person accepting the proposal may put an end to the agreement enforceable by law unless he has signified by words or contact his acquiescence in its continuance. Section 63 says this: every person who accepts a proposal may dispense with or remit wholly the performance of the proposal made to him which he has accepted, or he may extend the time for such performance, or may accept instead of it any satisfaction which he thinks fit. Taking everything into consideration, plaintiffs, upon the ancillary breach of defendants, claim to have put an end to the contract. However, it is the plaintiffs themselves who, by wrongfully refusing to take deliveries under the contract, have given a chance to defendants to put an end to it. Nevertheless, defendants did not exercise this option and by acquiescence continued it, but plaintiffs, by insisting on cancellation of goods, had expressly dispensed the performance by the defendant, such that no claim for damages could be brought against any breach by latter. This is my personal view on this case. Following the ban in London prohibiting the export of cotton goods in wooden cases and tins, the defendant made arrangements to supply the goods to plaintiffs in bales. The plaintiff has said to cancel the goods, but they have only made a breach of contract and have given a chance to the defendants to make the contract void. But the defendants chose to continue it, and the plaintiffs have no say in it anymore, and the damages cannot be claimed. The real question is whether to consider the contract as subsisting, and could the plaintiff claim damages? No, both are not possible. So the suit was dismissed. Thank you.